To Dr. Baldwin, Lillian Gray, and to each of you, it's good to be here today. When the Justice Department under George Bush filed the complaint against the members of the new Black Panther Party, it invoked a rare provision of the 1965 Voting Rights Act to allege voter intimidation. The civil authority allows for civil cases of voter intimidation to be filed, and the provision has been used successfully only 3 times since its passage. This was the second time that the Bush administration filed suit under this provision. Both times it filed suit, it targeted black defendants. Now, interestingly, the common denominator in both of these cases is Attorney Adams, who just spoke to us, who compiled the Black Panther case and also worked on the 2005 lawsuit against black officials in Mississippi who were accused of discriminating against whites. Now, this particular provision of the law is used rarely, since most criminal acts of voter intimidation are usually referred for prosecution. Now, the first known case he talked about a little bit that happened in 1992 was filed against North Carolina Republicans against the campaign of then Senator Jesse Helms. And what happened in that particular case was they sent postcards to 100,000 mostly black voters with misleading information about election laws. A distinct difference between a systematic process of attempting to suppress or to violate the voting rights of 100,000 individuals and this particular case of 2 individuals in Philadelphia. There were no more cases filed under this provision until 2005. And then the Black Panther case. The 2005 Mississippi case and the Panther case are the only times the Department of Justice has used the authority of the Voting Rights Act to allege voting discrimination by blacks against whites. Now, perhaps you've heard about Attorney Adams in his bio, but I think it's important to talk a little bit about his background so we understand the crux of this whole notion that the Obama administration is somehow discriminating against the rights of white voters. We know that Attorney Adams is a career voting section lawyer, but he's also a foot soldier in the conservative movement. His background helps to explain how this relatively minor incident in Philadelphia during the presidential election involving 2 members of Yes, I Agree, an anti-white, anti-Semitic fringe group who really have no credibility, but it all of a sudden blossomed into this potential controversy for the president's administration. He previously volunteered for the Republican National Lawyers Association, which is an offshoot of the Republican National Committee that trains lawyers to fight on the often racially tinged front lines of voting rights. He was a Republican poll watcher in the 2004 presidential campaign. He was a reviewer on the manuscript of a book that basically questioned the contemporary need for Section 5 in the Voting Rights Act, which was a statute that he was tasked with enforcing. He wrote a piece for the American Spectator that likened President Barack Obama's worldview to that of Nazi appeasers and argued on a conservative blogging network that health care reform was a threat to liberty. Now, Attorney Adams compiled the lawsuit against the Black Panthers, 2 of whom stood outside of a majority black Philadelphia polling place in November 2008. They had on military-style fatigues. One of them was carrying a nightstick, so that you know exactly what the weapon was. Now, after the Department of Justice dismissed the complaint, outraged conservatives called for an investigation. Republican lawmakers called for an investigation into whether politics played an improper role in the decision. Now, I'll talk about the merits of that case in a moment, but let me suggest to you that the manner in which the Bush Department of Justice used Section 11 really turned the spirit of the Voting Rights Act on its head. The 1965 Act was passed amid incidents of beatings, harassment, murder, lynching in the South by white mobs, by the Ku Klux Klan against blacks, and against people demonstrating for black voting rights. It came in response to government-sanctioned racial discrimination. It came to protect the rights of those who had long been discriminated against, disenfranchised, and denied their rights as American citizens. Now, sadly, the only two Section 11B cases that were brought by the Bush Department of Justice have been on behalf of whites who were never systematically denied their fundamental right to vote, who were never systematically lynched, harassed, murdered, or disenfranchised by laws and practices that were sanctioned by the U.S. government. So I submit to you that this whole notion really spins the intent of the Voting Rights Act on its head. Now, when we talk about this particular incident, in order to pursue a voter intimidation case, there should be depositions from voters who actually felt intimidated, and the action should be shown to be part of a larger campaign, such as the 1992 North Carolina case, which was part of a large campaign to discriminate against a large number of voters. The Black Panther complaint provided little evidence to support the government's allegation that the group conducted a widespread, coordinated campaign to intimidate voters. They haven't brought up any incidents in any other parts of the country, with the exception of this particular minor incident in Philadelphia. J. Gerald Hebert, a former acting chief of the voting section of the Civil Rights Division, said that the case against the new Black Panthers was, quote, on shaky ground from the beginning, and was largely filed by the previous administration for the new administration to have to clean up, putting them in a difficult position, end quote. Incidentally, Hebert has written extensively about Section 11B. No voters registered in the majority black precinct in Philadelphia where this incident occurred came forward publicly to say, I was intimidated. The complaints were filed by the white Republican poll watchers. On election day, a call came in to the office of John McCain in Philadelphia saying that two black men in military fatigues and berets were standing outside the polling station, and one was carrying a nightstick. A gentleman by the name of Stephen Robert Morse, a freelance journalist who'd been hired by the local Republican Party to document potential irregularities, went to the apartment building on Fairmount Street, and he began to videotape the so-called incident. The rest is YouTube history. Only 34 whites live in the precinct where the incident took place out of a total of about 1,000 residents, according to the census data. But there was a sea of white faces there on election day, mainly Republican lawyers who'd come to monitor the polling stations and what, since the 2000 presidential campaign, has really become commonplace for both political parties. One of the Republican poll watchers called the police. King Samir Shabazz, one of the new Black Panther Party members, was taken away without incident. The other Black Panther, Jerry Jackson, who'd actually been issued a poll watching certificate by the Philadelphia County Board of Elections, remained. The police saw no need to remove him from the premise or to charge him with anything. There were no racial epithets recorded on Morse's video. You will see, if you look it up on YouTube, you will see no confrontation with potential voters captured on video. No use of the nightstick is captured on the video, just an exchange between the videographer and the Black Panther members. Along comes Fox News, and they interviewed Republican poll watchers who described a more volatile scene that allegedly took place before the video cameras actually showed up. the unfair and unbalanced news station, led with news stories of voter intimidation. So then 13 days prior to President Barack Obama being inaugurated, the Civil Rights Division files a lawsuit alleging that Shabazz and Jackson, they hurled racial insults and threats at individuals in Philadelphia. They made menacing and intimidating gestures directed at individuals who were present to aid voters. And those individuals who were present to aid voters who are protected under the law, as Attorney Adams has told you, of course, were the Republican poll watchers who reported the incident, the ones who gave the interviews on Fox News. No voters of any race in that precinct came forward publicly to say they were intimidated. Now, if you find me some voters, I'll buy you a copy of his book and send it to you. No voters have come forward to this day to say that I was intimidated or I was harassed. Now, Republicans have suggested that the Justice Department dismiss the case because the new Black Panther Party helped Obama get elected. Now, according to David Norcross of the Republican National Lawyers Association, he is quoted as saying, "It just smacks of some kind of deal or a thank you payback." But a review of Shabazz's comments before the election indicate that he was not even an Obama fan. Matter of fact, he is quoted as saying, and I quote, "Obama is a puppet on a string. I don't support no black man running for white politics. I will not vote for one who will be the next slave master," end quote. He told this to the Philadelphia Daily News just days before the election. Now, both in his book and more recently, teaming with Sean, I Hate Obama Hannity, Attorney Adams made claims that President Obama is all of a sudden best friends forever with the Panther Party because they happen to share the stage in a 2007 march. Now, this march happened to mark the 42nd anniversary of the Selma March for Black Voting Rights, which ended with police brutally beating the protesters, including Congressman John Lewis. Other politicians were at that march, yet Mr. Adams, along with others like Andrew Breitbart, see the episode as evidence of the president's alleged racial radicalism. As a matter of fact, Michelle Malkin, for example, calls the march the Obama New Black Panther Party March, as if they somehow together came forward to organize it. Now, how disingenuous can you get? To tie the president to the Panthers simply because they were at the same place at the same time for the same march is like saying that I am a conservative Republican simply because I'm participating in an event sponsored by the Federalist Society. So the Justice Department, in my estimation, rightly decided that this incident did not constitute an orchestrated campaign or pattern to deny voting rights, which is the usual criteria for deploying federal resources in litigation. Further, they refused to seek legal action in part based on how the men were dressed, and noted that one of them, Jackson, held an official poll-watching certificate which gave him a legitimate reason to be present on the premises. Now, Mr. Adams' story of a racial bias by the Obama Justice Department was conclusively debunked by the Department of Justice Office of Professional Responsibility, who investigated the handling of the case and determined that all parties had, quote, acted appropriately, and that there was, quote, no evidence to support the claims that the decision of senior Department of Justice attorneys who overturned Adams and his trial team were improperly affected by political considerations or by the race of the defendants.